You know, at many times in our lives, we're faced with decision making, and sometimes we can't make those decisions ourselves, and we have to have a power of attorney. Well, what is a power of attorney? Well, to answer that question for us, we decided to call on our expert, Jeffrey Williamson. Hey, Jeffrey, how are you?
Good to be with you.
I know you have the wonderful information for me today having to do with power of attorney because, you know, we often hear that term, power of attorney. But many people, if you said, what is a power of attorney? They would say, I have no idea. So what is a power of attorney?
It's a document that gives a person, your agent, someone you designate as your agent, you being the principal, to act on your behalf. Most powers of attorney in estate planning context are durable, meaning they survive your incompetence. And that's what they're done for. That's what the purpose is saying, when I'm no longer able to make decisions for myself, I want Natalie Hendricks or whomever I designate to act as my agent, my attorney in fact, sometimes it's called.
So when is it that you need to make sure that you have a power of attorney?
I would say most people should have one in place. Now, you can have them that are effective immediately. In other words, I could do one right now naming you my power of attorney, my agent, my attorney in fact, whatever term you want to use, and you could act right now. And that would not, many clients are under the misconception that that dispossesses them of the right to act on their behalf. It wouldn't. It would just allow you to act for me as if you were me. Now, you can have them, though, that are springing. So you can have language in the document that says, hey, Natalie can only act if a doctor declares me incompetent. Someone as young as you are, I would say let it be springing. You know, only if I cannot take care of myself or if I'm deemed incompetent. When a lot of my clients, though, you know, as you know, I specialize in elder law. Someone coming in, mom is 85 or 90, we're getting a power of attorney for the daughter or the son. I generally, not always, but generally or frequently make them effective immediately.
So how long, is there a certain time period where, you know, if you become a power of attorney, is there a certain time period that lasts, and can you delay the effective date of a power of attorney?
Well, you can delay the effective date, as I said, by making it springy. Okay. Say it will only come into effect if, for example, a licensed physician says, you know, I'm no longer competent. Or you can make it to where a judge has to say. Generally, though, when I'm doing them in an elder law context, I make them effective indefinitely. Now, as long as you're competent, you can always revoke it. But if it's for an elderly person, you make it durable so that it survives their incapacity. And if they're not competent, then you're saved from having to go to court because you've got this document giving you this power.
So you can draft a power of attorney to guard against elder abuse.
You can, and that's one thing. Not all powers of attorney are created equal. I see clients that come in, they've got this one-page form that says, hey, Natalie can do anything and everything and act on my behalf. Well, there's no law in Georgia now requiring a bank or any other institution to recognize that document. That's why we often use trust in other contexts. But the more specific you can make it and the more detailed, for example, mine has specific provisions over retirement plans, insurance, and you mentioned elder abuse. There's a special provision in there saying that if the principal, the person giving the power of attorney, wants the agent to give an accounting, he or she can order that. Now, a lot of documents don't allow for self-dealing. And that is good in some contexts, but if your mother, if you're the power of attorney for your mother, she probably would want you to have some self-dealing.
So say, you know, I've established and I have someone as power of attorney, or I'm a power of attorney myself. How often should I update this, or is this something I should revisit, you know, over a period of time?
A power of attorney is a crucial part of your estate plan, and I tell my clients generally to review their overall estate plan every 3 to 5 years. But if you have a significant change, a death in the family, a divorce, then you need to review it immediately. So generally every 3 to 5 years, unless you've got a major life change, then I would review it then.
And when you're thinking about estate planning documents and that kind of thing, you really should, that's something that you should do early on as well and not wait until it's too late.
Well, if you wait till it's too late, you can't do it. Then you're left to the court system. So it's either, it's either pre-planning or the court.
So definitely the information and the thing that we want to remember is pre-planning always is the way to go, especially when you're dealing with this.
Absolutely.
Jeffrey, thank you so much for all of your information.
You're welcome.